rights of landlord and tenant. What you need to know about recovery of premises is what we'll be discussing today. This is C&B Advisory, and if you've not subscribed already, this is the best time to do so. So you can subscribe right now. So without wasting any of the time, let's get into it right away. So this is the concept of recovery of premises under tenancy law. The procedure for the recovery of premises is generally regulated by statutes, and in the absence of any separate agreement with respect to period of notice to be given to a tenant, a landlord is expected to comply with the provision of the Lagos State tenancy law, especially in terms of notice before he can recover his premises from a tenant, and going contrary implies that such eviction is invalid. And in Lagos State, the following laws govern recovery premises. The first one is Lagos State Tenancy Law 2011. The second one is Rent Control and Recovery of Residential Premises, Edict number 6, 1997 of Lagos State. Then the third one is Recovery of Premise Law, Cap 118, Laws of Lagos State 1973. Then the fourth one is Magistrate Court Law, Laws of Lagos State 2009. Lagos State Tenancy Law 2011 provides that a court shall have jurisdiction to determine matters in respect of tenancy of any premises let before or after the commencement of the law. The law further provides for the interpretation of the word court to mean High Court or Magistrate Court of Lagos with the exclusion of customary courts. It is important to note that the law does not apply to the following premises and location in Lagos State: residential premises owned or operated by educational institution. The second one is residential premises provided for emergency shelters, and the third one is residential premises in a care center, hospital, whether public or private, or mental health facility. Then the fourth one, premises made available in the course of providing rehabilitative or therapeutic treatment. Also, the law does not apply to Apapa, Ikeja GRA, Ikoyi, and Victoria Island areas of Lagos State. It is worth noting that the areas where the law does not apply, the Rent Control and Recovery of Residential Premises, Edict number 6, 1997 of Lagos State, and the Recovery of Premise Law, Cap 118, Laws of Lagos State 1973, would apply to residential and non-residential areas respectively. The types of tenancy relationship determines how the tenancy can be determined. So we have the periodic tenancy. A periodic tenancy can be monthly, quarterly, or yearly. The selected form of periodic tenancy must be expressly stated on the face of tenant agreement. Where this is not contained in the tenancy agreement, it shall be determined by reference to the time when the rent was paid or demanded. Then the second one is fixed tenancy. Unlike periodic tenancy, fixed tenancy contains a clearly detailed tenure of the tenancy. Hence, it could be for a specific period of time, or months, or years. However, regardless of the form, the term must be certain and clearly stated, i.e. commencing from May 12, 2023 and ending on June 12, 2023, like that. So it should be noted that the distinction is very crucial because of the legal consequences attached to them. So a landlord desiring to recover possession of premises let to his tenant shall, firstly, unless the tenancy has expired, he has to determine the tenancy by servicing the tenant an appropriate notice to quit. Then the second one, on the determination of the tenancy, he shall serve the tenant with a statutory 7 days notice of intention to apply to court to recover possession of the premises. Then the third one, thereafter, he shall file his action in court and may only proceed to recover possession of the premises according to law in terms of the judgment of the court in the action. So the landlord must comply strictly with the provision of the statute. Where a landlord derogates from the procedure, an action can be maintained against him by the tenant depending on the level of derogation. The landlord also risks rendering himself for a trespass action. So those are the procedure for recovery of premises for periodic tenancy. A landlord who intends to file action in court for recovery of premises from a tenant can seek an order granting him the areas of rent, the profits, and the possession of the apartment. A tenant can be evicted or have the premises recovered from him on any of the following grounds. Premise is being used for immoral or illegal purposes. The second one is the premise has been abandoned, or the premise is unsafe and unsound as to constitute danger to human life, property. Then, the tenant or any person residing or lodging with him or being his subtenant constitute by conduct an act of intolerable nuisance or induces a breach of a tenancy agreement. So in the absence of a tenancy agreement stating the notice to be given, the landlord is expected to issue notice in accordance with Section 13 of the Lagos State Tenancy Law 2011, and it provides that where the tenancy is an annual tenancy, the tenant shall be entitled to a 6-month notice to quit, and upon the expiration of the notice to quit, the relationship is deemed terminated. Where the tenant still holds over the premises, the landlord or owner can then serve the tenant with a 7-day notice of owner's intention to recover possession. So finally, where the tenant fails to give up possession at the expiration of the 7 days notice, the landlord can then apply to court for a court order evicting the tenant by way of summon, with particulars of claim annexed thereto. So this is the procedure for recovery of premises for fixed tenancy. Evicting a tenant under a fixed tenancy is a bit different from what is obtained under a periodic tenancy. Since a fixed tenancy is always for a term that is certain, the relationship is deemed terminated or determined at the end of the tenancy or at the termination date contained in the tenancy agreement. So the implication of this is that the landlord does not have to serve a notice to quit on a tenant to determine the tenancy. In order to recover possession in this type of tenancy, the landlord must serve the tenant a 7 days notice of owner's intention to recover possession. However, where the notice is less than 7 days or served within the term of tenancy, it will be declared invalid. Are the rights of a tenant. Over the years, the various regulatory frameworks and judicial authorities donated several corresponding rights to the tenant, which helps guarantee peaceful occupation of a demised property. The following are some of the rights that accrue to a tenant. The first one is the right to a written agreement. On concluding negotiations to a premise, the tenant has a right to ask for a written agreement and be comfortable with its clauses before executing same. This is advisable because it will make it easier to prove the terms of the tenancy, which creates the right and obligation of the parties. The second one is the right to the issuance of payment receipts. Upon payment of rent, the tenant has the right to request the receipts of payment signed by either the landlord or any of his authorized agents. The receipt is the proof of the tenant's rights of occupation and the use of the property, exclusion of any other person, the landlord inclusive. Then the third one is the premises must be in a habitable condition. It is the duty of the landlord to ensure the property, which is a subject matter of the tenancy, is fit for the purpose and in habitable condition. By this, all latent defects in the demised premise must be fixed by the landlord prior to the commencement of the tenancy. Part 1 is right to quiet possession. Once an agreement is reached and payment is made, possession is granted to the tenant, who now has the right of exclusive and quiet possession of the property. This means the landlord or anyone acting in his stead can be liable for trespass if he enters the demised property without the tenant's permission or express provision of the agreement allowed for such entry. So the next one is the right to notice to quit. A landlord is prohibited from using self-help to evict a tenant in lawful occupation of a demised property, irrespective of express contravention of any covenant of the tenancy, written or unwritten, express or implied by a tenant. The landlord is compelled by law to issue the tenant a notice to quit, except where the tenancy is for a fixed period of time, or is in arrears or rent for a period for which it is entitled to notice. It should be noted that neither the landlord nor the tenant can breach the agreement or waive it or reduce the minimum stipulation of the period of notice provided by the law. The last one is the right to 7 days notice to recover premises. After issuing and serving the requisite notice to quit on the tenant, the landlord must issue a compulsory 7 days notice for owner's intention to apply to recover premises. These are the rights of the landlord. Like the tenant, the landlord has some rights that the various regulatory framework and judicial authorities guarantee, prominent among which is the reversionary rights in the demised property. Others include the following: rights not to issue a quit notice. A landlord may not issue a quit notice where a tenant has waived his right to a quit notice in the tenancy agreement, or where a tenant is in arrears of rent for a period for which he is entitled to notice. However, the landlord must issue a 7 days notice of owner's intention to recover possession. Then the second one is right to review rent and renew tenancy. While the landlord reserves the right to review or renew rent payable on the demised property, including a rent review clause in the tenancy agreement before execution is advisable. Right not to reimburse a tenant. A landlord may refuse to reimburse a tenant for any repair done on the demised property if there was no previous agreement to that effect, or where the initial agreement does not cover such repairs. So these are courts with jurisdiction. The jurisdiction to certain recovery matters is vested in the magistrate courts, district courts in the north, and the high court, section 2 and 4 of the Lagos State Tenancy Law 2011, provide that the proceedings shall be instituted under the law at the high court if the annual rental value of the premise exceed the jurisdiction of the magistrate court. Accordingly, the grounds on which the landlord can invoke the jurisdiction of the court in the recovery of premises to recover possession include the following. The first one is arrears of rent. The second one is where the landlord requires the premise for his use. The third one is a breach of an express covenant contained in an agreement, and the fourth one is where the substantial repairs are to be done on the premises. So let's talk about eviction of a tenant for breach of covenant. Most written tenancy agreement contains covenants that binds the parties. A covenant in a lease is an agreement or promise in which a party pledges himself to do or refrain from doing a thing. Covenant in a lease may also provide for the truth of the specific fact. Such covenants may be implied. So this is where we draw the curtain today. I'm sure you've learned so much. So if you have questions, you can drop it in the comment section right now. And if you've not subscribed already, what are you doing? This is the time to do so. So subscribe, save, share, like, turn on your notification bell, and follow us on all our social medias as well. And again, you can book an appointment with us at C&V Advisory for all your legal advice and all that. So see you some other time. Bye.